Get ready. This is your chance to ask questions about family law, from marriage to divorce, from birth to death, and everything in between. Call in right now, live, on a special hour-long The Law Works.
From West Virginia Public Broadcasting.
Closed captioning for The Law Works is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The Law Works is made possible by a major grant from the West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and legal system, promoting public knowledge of the law in West Virginia. By the generous support of Software Systems Incorporated, a West Virginia company established in 1975, providing high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems. And by viewers like you.
Tonight is your chance to ask questions. The topic is family law. The number to call is 1-800-375-4049. 800-375-4049. My guest is family law attorney J. Douglas Crane. Doug, thank you for coming back yet again.
My pleasure. Thank you. I always enjoy being here.
We do one of these shows a year with live call-ins, and you're always the guest because it works.
Yeah.
And welcome to the most dangerous hour on television. It's not dangerous for you because you're just calling and asking questions. It's dangerous for Doug and for me because we're going to try to answer your questions. The topic again is family law, from marriage to divorce, from birth to death, everything associated with being a family, the relationship between the members of the family's obligations to society. And once again, the number to call is 1-800-375-4049. Doug, I got a news release this afternoon from the Center for Disease Control and Prevention, and this was an eye-opener. It said 40% of the births in this country, nationwide, 40% of the births in this country are to unwed mothers. 23% of the births in this country are to unmarried mothers, unmarried couples who were living together at the time the child was born. So they had formed a family unit, but they weren't married, they were having children. And that's an increase of 9% over the last 10 years.
Wow, that's surprising.
Well, and we do see it. We don't necessarily appreciate the numbers when we see it, but those are the numbers. What are the problems associated with having children outside of marriage for a couple?
As long as they remain a couple, there are no problems. It's when they decide to go their separate ways that can create a huge amount of problems. I would say that almost 0%, a small percentage of people actually enter into some kind of a legal arrangement with their significant other. The biggest problem I see is that child support, if they separate, the primary residential parent will get child support.
Now, primary residential parent, we used to talk in terms of custody.
Right.
We don't do that anymore.
No, the primary residential parent, when they redid the code, is the person who the child lives with approximately 51% of the time, or just over half the time. With that is, people ask me all the time, I want full custody, or I want custody, and I said,
I want to fight for custody.
Fight for custody. And I said, what is it you want? And generally that's joint decision making because they want to have a say in the rearing of their children on where they go, what they do, extracurricular activities. And so they want to have joint decision making on those things as the child grows along. The problem with unmarried people raising a family, once they separate, causes a great deal of problems. They have no agreement. There can be no spousal support because they were never married. The property is, since they're single, what's in his name is going to stay in his name. What's in her name is going to stay in her name.
No matter when they bought it.
No matter when they bought it, where if you're married, the court doesn't care whose name it's in. If it's acquired during the marriage, it's a marital asset. or marital liability, depending on what the case may be. So it's a whole different set of rules.
People don't realize the benefit of the marriage, even in time of divorce. In divorce, if you and your spouse own a house, then in theory, generally, each of you own half the house. There are some caveats associated with that, but you get the benefit of owning half of a house, even if you're not living in it. If the house is sold, each of you get half of the money that you realized for the sale.
Half the net.
Half the net. So when we talk about having a child and you're not married, you will get child support, although there are some technicalities about making sure we know who the father of that child is. But once that's resolved, it can take a while, you will get child support if you're the primary residential custodian or parent. That is, you have custody of the kid.
Yeah.
But you don't get the benefit of any of the investment that was made into the house. You don't get one of the two cars, if you have two cars, if they're both in the name of the other person. It's like it never happened. And child support, frankly, just isn't enough to raise a child. You have to have shelter, you have to have medical care, and all that too.
And child support is calculated based on the income of both parties. And also, we have the extended share thing, which depends upon, there are some people who actually work out a true, what they say, joint custody. I've got the child 182 and a half days out of the year, and you've got the other 182 and a half. They actually have split the time exactly 50-50 with the child. Most people have a problem with their schedule, dad's schedule, mom's schedule. If they're both working, but some people make it work, and more power to them.
Well, but sometimes...
But child support then changes with that.
And it's a mobile society, and sometimes people move to take a better job. Sometimes they move a mile, sometimes they move 25 miles, and sometimes they move 3 or 4 states away.
Absolutely.
And things get very, very difficult then. If you are in a situation where you have formed a family unit, you are not married, and now you're going to have children, how about before you make the decision that you're going to have children, you see if you can agree enough with the other person that you might be able to get married, because it makes life so much easier. Now, we're not saying that that's right, that's the way society ought to be. There are differences of opinions about that. But from a couple of lawyers, it will make life for all 3 or 4 of you a whole lot easier if there's a marriage, even though you have to go through a divorce at some point.
It's a great benefit for the children.
Immensely a great benefit. We have our first caller, Kimberly in Kanawha County. Kim, you have a question for us.
Yes, Dan, and thank you so much for taking my call. I love your show.
Thank you.
I have an aging parent. My question is, with a parent who has been diagnosed with dementia, is it possible for me to still get power of attorney with her not really being of sound mind?
We don't want to hear the last part at this point.
You've answered your question, because a power of attorney must be signed by someone that knows, that has their faculties, oriented times 3, I believe is the way the doctors describe it. If a doctor says that your aging parent has lost his or her faculties, the power of attorney is not valid.
Has she been adjudicated, I'll say, as incompetent? That means, that's a layperson's term. Does she have a guardian or a conservator to help her out?
No, not at this point.
Okay. Technically, she's legally competent so long as that process hasn't occurred, and that's an involved process.
Well, not to involve the county commission. A doctor sits down and you get to say that, and you can get the same things through your power of attorney with a conservator or a guardian.
Right.
You may have to put up a bond, and I mean, it's a little more costly.
The power of attorney document is a wonderful document, but a dangerous document. Mm-hmm. With a power of attorney, the person who holds that power, who is given that power, is, for legal purposes, the person who signed it. They have all the authority that document describes for the person who signed it. That means that they can go out and take all the money out of the bank accounts, they can sell the car, they can sell the house, they can sell the shoes and socks. So you have to be very careful to whom you're giving that power, because it is so dangerous. But between parents and children, husband and wife, it's pretty common to do that. And I always recommend that a power of attorney be signed. Now, in most cases, when a parent signs a power of attorney to their child, nobody's going to complain about the technicalities of that. So long as the person signing the document is reasonably competent to talk to the notary who is acknowledging the signature, and the document does have to be notarized, you're not
Right,
going to
I
have
know
any
that.
problems.
Yeah.
Now, for some people, I recommend the following, because that document is so dangerous. Don't give it to the person who's going to be entrusted with the power. Give it to somebody else. If you have 2 children, give a power of attorney naming one of your children, but turn it over to the other one with the instruction that you deliver this document when it's time to use it, when it needs to be used. Your next door neighbor could hold it for you, for example. You have anything else, Kim?
No, I think you've answered my question.
Okay. Also, a power of attorney is a really inexpensive document to have prepared. The process of applying for a guardian or a conservator,
Takes time, money, and you're looking at maybe $1,000 or $2,000. You also have to put up a bond that's renewed every year.
and there
I
are
see.
all kinds of financial reporting requirements. The
Annual
process to
report.
get the guardian, conservator, that's 2 different things, but usually it's done at the same time. Appointed takes 90 days.
Yeah.
Typically, and it does cost a couple $1,000s. So it is much better to sign a power of attorney in advance. In fact, I always recommend that people have a medical power of attorney, a living will.
And we call ours a durable power of attorney because once I sign it, if after the fact I'm found incompetent, the power of attorney survives.
Many years ago, if you suffered a stroke and became legally incompetent, your power of attorney terminated. And we all realized that really wasn't such a good thing to have happen.
right.
It defeated the purpose of the power of attorney document. One of the questions that I get so often is, how's child support calculated? If we're married, we're getting divorced, and one of us is going to be the primary residential parent, they're going to get child support. How's that determined?
Child support's based on the adjusted gross income of both parents. There's software put out, and it's called Support Calc. And all the judges have it, and I'd say the vast majority of attorneys that do any family law have that. So once you get the numbers, it's pretty well a set number. There are only 2 things or 4 things you can take off as deductions. You have the child's portion of health insurance. So if I have insurance for my family, and it costs me $300 for me, and then I have a family plan, and it costs $200 for the family plan, and then that family plan is my wife and 2 other children, then the children's portion of that will be as a deduction on the child support formula. Extraordinary medical expenses and daycare cost. After you put those numbers in, the number kicks out amount of child support that is paid per month. I get a question, well, I've got the kids all summer, so I don't have to pay child support. No, child support is based on an annual basis, paid 12 months a year. Parents that have children can't unrent their apartment, or they can't cut off the electricity when they don't have the kids. It's 12 months child support, period.
Well, another really important thing about child support, and we get these calls all the time, is I lost my job 6 months ago, and now there's this huge child support arrearage because I haven't been able to pay for the last several months. I need to get my child support adjusted. And you're going to be stuck with those arrearages. You have to pay the back child support.
The courts cannot monitor every person. So if you have a tremendous change in your job, or mine shuts down or you lose your job, you need to get to court immediately. Now, the court may not hear you for 30 or 40 or 50 days, depending upon their backlog, but the child support recalculation will go back to the date of your filing. So they'll give you credit for that. If it takes 2 months to have a hearing, your child support retroactively set back to the time you filed, which is the fair thing to do.
So the moral of the story is, if you lose your job or if you're injured and unable to work, as soon as you can, the next day, if possible, file a petition to have your child support at least reviewed.
Yeah, you can file a pro se petition or get with an attorney and get it done. One of the things that people about changing child support is that generally child support number does not change unless it's a material change, and our statutes say that has to be 15%. So if I was paying $500 a month in child support, and I had a few bad months where I was cut back or whatever,
Lost your overtime.
lost my overtime, that's a different issue, but
Well, yes.
yeah. But so if I recalculated with the same figures and it came down to be $75 off of that, $426 would be my new number. It wouldn't change because it's not 15% of my original child support.
The moral of the story is, talk to your attorney or find an attorney that you can talk to. Because child support is so predictable with formulas and charts and tables and all of that, we can tell you with some fair assurance whether you are eligible to have your child support adjusted up or down. And up is a possibility. If your child support was set when you were making X number of dollars and you got a couple of pay raises along the way and now your income's cut back a little bit, you may still have an upward adjustment.
It may be upward on the fact that the time you were divorced, maybe your spouse was not working. And so you were the only number used and they attributed income to your spouse. Now the spouse has a job. So originally you were 90% of the pie of your income. You may have a small percentage of the pie, but it may be a bigger number. I've actually seen where somebody was not employed, got employed. The other person came in and said, my child support's going to go down. It actually went up because the percentage of the child support number decreased, but it was a much bigger number.
It's predictable, but it's complex, and it requires full disclosure of financial information from both parties every time. We're talking about family law, from marriage to divorce, from birth to death, and everything in between, and we're taking your calls. My guest is family law attorney J. Douglas Crane. We're live, and the number to call is 1-800-375-4049. 800-375-4049. I'm Dan Ringer, and this is The Law Works. Have a second call. Paul, have a question about trusts, I believe.
Yes, my call is in regards to a revocable trust. How long does it have to be in existence before one expires? And as far as, is there any probate involved?
Trusts are governed by the terms of the trust.
For the trust. And you'd have to actually read that document to see. I can't answer that question now.
Well, in general terms, if a trust is revocable, it's revocable.
And its terms would be set forth in the trust document.
Yeah, if there is some condition that has to be satisfied before it can be revoked, then you do that. You have to satisfy that condition before it can be revoked. With regard to probate, if your property is in a trust, then in general terms, no, it is not part of your probatable estate, depending upon the length of time after the trust was. There are other considerations. It is a highly specialized area of law. You may have seen books entitled such things as How to Avoid Probate, and one of the things that they recommend there is that you use actually non-revocable, I believe, family trusts. Non-revocable family trusts, once you put the money in there or the property, whatever it happens to be, it's there and it's going to stay there and you can't get it out. And otherwise there would be horrendous tax consequences to it.
Right.
Revocable trusts are more matters of convenience. The most common trusts that we see with regard to estates are the trusts that are established in wills for infant children or for children who suffer from some sort of significant incapacity where they're likely to not be able to take care of themselves.
Yeah, it springs out of the will. The trust doesn't exist until someone dies, and then the assets come in and spring for the benefit of a minor child.
Yeah, and generally those aren't done to avoid probate expenses or to save taxes. They're done to create an income stream or at least asset availability for the care of somebody who's going to need it.
Yes.
We frankly usually prepare those when somebody comes in and has minor children. That's very common. To do that is a fairly simple thing. The language in those kinds of trusts is pretty much boilerplate. The trick is finding somebody to take responsibility for administering the trust.
And or the child. The property is one thing, the person's another.
You actually need three things.
Yeah.
You need an executor for your estate. Now, the term executor is the male term. Executrix is the female term. We've kind of gotten away from putting gender labels on that role. So you have to have an executor to oversee the probate of your estate. You need a guardian for your infant children.
Of them, who actually physically takes care of them. And they may or may not be the same person that has the money. That's an individual choice. I mean, I've seen people go both ways. You know, my brother's the greatest person to take my child, but I want my sister to hold the money, or vice versa. Or he does everything, and have my brother handle it all.
Right. The trustee is the third person. So you have to have an executor, a guardian, and a trustee. They may all be the same person.
Maybe.
but they don't have to be the same person. And actually, there is a bit of a benefit to having a separate trustee and a separate guardian, because that puts a little bit of protection for you or for your estate in making sure that the money's properly applied. Otherwise, we end up with some sort of Dickinsonian situation where the guardian is making off with the money and stuff like that. And we have another caller on the line. Virginia, you have a question for us.
Yes, sir. Thank you for taking out my call.
Certainly.
This is concerning some land in Nicholas County in West Virginia, and it's and by my father. It's in my father's name and his brother's name, and it has never been divided. And we have been paying taxes on it for many years, and we cannot get them to pay the taxes. We tell them what they are and everything. And is there any way we can go ahead and get the property in our own names for both pieces of the land for us, or can we? How do we get that done?
Okay, let me ask you.
Pay the taxes.
Let me ask you a couple of questions, Virginia.
All right.
This property was somehow came into the name of your father and your uncle. Is that correct?
That's correct.
Are they now deceased?
They're all deceased. My grandfather left it to them, and they're all deceased.
Okay. You've got several questions there. First of all of the heirs of your father and your uncle own the property in accordance with the estates of your father and your uncle. For example,
That's
if your uncle left a will leaving the property to 2 of his 5 kids, then those 2 kids own it. If he died without a will, then all 5 of his kids would own it, and maybe their kids if one of his kids died along the way. So you end up with maybe multiple owners. That's a problem because you can never get that many people to agree to anything.
Yes, that's right. Okay.
Now, can you divide the property? Yes, you can force a division of the property through what is called a partition lawsuit. That means one of the owners has to come in and ask the circuit court, in this case in Nicholas County, through a lawsuit, to have the property valued, probably have it surveyed, and then divided into parcels of equal or appropriate value, or if it can't be divided, to sell it. Now, the other problem is you've been paying taxes on it for a number of years. Do you get any advantage as a result of that? And the answer is probably no, you don't. Because
No, we do not.
you would get an advantage if you pay the taxes on the property if you filed a written lien with the county clerk's office. Each year you pay the taxes, and then you're entitled to a lien in the amount of the taxes that you paid, and when the property's sold, you get that back. That's usually a relatively small amount of money, but you have to file that piece of paper every year, and you only have a certain number of days to file it. So otherwise,
Okay.
you are considered to be a volunteer for all of the other owners when you pay the taxes, and they can say, "Thank you, ma'am, for paying the taxes." They don't owe it back to you. They don't even have to say thank you. You are paying it for everyone who owns the property. Now, I got into that
understand
because
now.
I used to do a bit of delinquent tax law stuff. So thank you, Virginia, for that call. Well, we talked about how child support was calculated. How do we calculate alimony?
Alimony. If you look at the statute, there are approximately 15 items that a court will look at to determine alimony, and each case is unique. You, as I say, what goes for the Smiths does not go for the Joneses. There are so many unique things in each case that you can't do a formula. Well, they're trying to come up with one, but a formula for alimony just doesn't work. The criteria is, first of all, the age of the parties, the health of the parties, how long they were married. Surprisingly, how long they lived together. There are people who are married that for 10 years and only lived together for 4 or 5. Their education, their ability to earn income, and how they are on their in their careers or whatever they're doing. You have a whole lot of factors. Alimony is a truly economic, I won't say disaster, but it's an economic question for the courts and the attorneys to sit down and work out. Plus, you have 3 types of alimony. You have permanent alimony, which is going to be paid for the life of the recipient. You have rehabilitative alimony, which is someone pays for, where I see it jointly, is that we're going to get a divorce and I raised some children, and I gave up my college degree. I need 2 years to finish my degree so I can become a teacher or a nurse or I want to become an accountant or whatever. So I need to go back to school, but I need some help. And so as soon as I get my degree, obviously I'll be in the workforce and be able to earn my own living. So the court is going to generally help that spouse, rehabilitate the other spouse to get into a better paying job and workforce. You have reimbursement alimony. What's that? Well, the typical story is that one's in school and the other one works to put the other spouse through school, and then they get their degree and they get divorced. Well, if you can show that you put that money, the court will make the other side reimburse you because you've helped them attain a higher station in life with a degree and a higher earning capacity, I guess is the way I word that. So.
But there are exceptions to all of that, and there are other colors and thoughts that come into each one of those factors. And when
You
somebody,
didn't get in default. That's another thing.
whether you were the one that caused the marriage to break up,
Yeah. I mean,
or whether you condoned the other person's wrongful acts.
that's what I say. They're just, each case is so unique and so different that, and the judges, family court judges, look at each case on a case by case basis, and I think all in all do a pretty good job deciding that.
We have another caller. Gloria, you have a question about the non-residential parent, I believe.
Yes, sir. If the non
Gloria, you're breaking up.
yes,
We're
and the
not
medical
hearing you.
decision making for the other party.
Okay, Gloria, you're breaking up a little bit. I'll restate your question as I think I understand it. You want to know what the rights are of the non-residential parent, that is the parent who doesn't have primary custody. I'm going to use the old
Exactly.
language. What rights there are with regard to medical treatment decisions and that sort of thing. Doug?
Not having seen your parenting plan, but generally medical decisions come in two types. One is emergency medical decisions, and that's pretty standard. If I've got a child and he falls off the swing and breaks his arm, I take him to hospital as fast as I can, and I tell the other parent. Now, non-emergency medical decisions are those elective things. I got a child that may need his tonsils out, or when my daughters are little, we had to have her ears holes in them to get rid of.
I want to have my nose fixed.
Yeah, well, I mean, those are elective things. I don't know what your parenting plan says, but those should be joint decision making with both parents. If you're going to take a child elective surgery, it's not something that is life-threatening. If it's life-threatening, you need to be on the same page with what the doctors, and if you want a second opinion, you're entitled to it. We actually have statutes that said both parents have access to all the records of a child, be it educational, medical, whatever it is, and so that you have a right to know what's going on with your child, be you the custodial parent or the non-custodial parent.
And if you're the parent of the child, so far as the medical community is concerned, you have the right to make decisions for that child unless there's a document written someplace that says that you don't.
Yes, that's correct. I mean, I said, but it generally comes in on some elective things. And you certainly want to know that if a father or mother doesn't think that the other parent is doing right, I've never seen a court not let you get a second opinion. I mean, and I encourage that. You want to make sure that before you do something, both mom and dad are on the same page with what they're going to do to their child, or what medical procedures are going to be done.
Okay, we have another call about child support and
Okay.
some related things. Jeff, you have a question.
Yes, sir. My question is, in regards to claiming the child as a dependent at the end of the year, like in my case, my wife is the primary custodian. She has custody of the child. I get him every 2 weeks. She's allowed to claim him on taxes, and I'm not. Can you kind of explain that, why that is?
It's the law in West Virginia that if the primary residential parent gets to claim the child as a tax exemption. Now, I see a lot of judges are adding a clause in there that will allow someone to do that, the non-custodial, in this case the father, but you run the taxes as though mom's claiming them, and then dad's claims them, and if mom's going to get $1,000 back as a refund, dad can go and claim the child and pay her $1,000, so there's no loss to her for ignoring the child. And if there's no economic benefit or tax benefit of the child, some courts will allow go ahead and allow the father to claim the deduction if he's paying him. If she's not working and never worked, then there's no tax benefit, and I hate to see the tax benefit go wasted. Obviously, she can agree, and if she's not agreeing, then you've got to go to the court to see what the situation is, whether or not you would be allowed to do that.
But if she agrees, she has to sign a piece of paper that you file with your tax return.
Absolutely. Which is, I say, if you have it in your court order that you can do that, then you just, a copy of that will satisfy the IRS, I believe. And if you have it that it's worked either way, then that order would say that you can claim it, but you've got to make sure that you reimburse her that what she would normally get back, or you're going to have problems.
Well, and I suppose the baseline question there is, why does that happen? And your answer is, it's the law.
It's the law. When they gave the legislature, and I'm not trying to go into why they did this, but the non-resident or the primary residential parent generally pays the first $250 of uncovered medical expenses for the child per year. So the legislature giveth and they taketh away. So that if you're paying medical expenses for your child, she's probably paying the first $250, and then your percentage kicks in after that on an annual basis.
Well, and we kind of addressed it at the beginning of the show. Child support really isn't enough to raise a child. It takes more input beyond that. Yeah. We call these things legal fictions. The legal fiction with regard to child support is that we can calculate a sum of money that is sufficient to raise a child, but the simple fact of the matter is it takes a lot of money to raise a child, and in a divorce it may well be that neither party is making enough money to raise the child, or that even both the parties put together can't raise the child.
The problem with divorces, and I say divorce is expensive, and they say, why? Is the attorney fees? I say no. It's because when you get a divorce, your expenses double and your income does not. I've yet to see somebody go to their employer and say, I'm getting a divorce. He says, Dan, I need to double your salary because you've got, it just doesn't happen. So I've now got either rent and a mortgage, 2 utility bills, to this, and that same pool of money is just not enough to go around in the vast majority of cases.
We're talking about family law, from marriage to divorce, from birth to death, and everything in between, and we're taking your calls. My guest is family law attorney J. Douglas Crane. We're live, and the number to call is 1-800-375-4049, 375-4049. I'm Dan Ringer, and this is The Law Works. We have another caller. Sue, you have a question for us.
Yes, Dan. According to the first lady that called, is it legal to sign a deed to sell property or sell a vehicle if you've been diagnosed with Alzheimer's? Thank you.
Yes.
Could be. Yes. It's not illegal.
That's right.
Phrase it that way.
The real question is, has there been an adjudication that the person is no longer capable of handling their own financial affairs?
Yeah.
In layperson's terms, we say that person is now incompetent. I don't like that term, but that's the lay term that
we're
we
fortunate that we're all presumed competent until we're adjudicated otherwise. Is that?
Yes, that's my rule, at least, that I apply. The honest and horrible truth is that Alzheimer's, dementia, mental incapacity, whatever labels we put on it, is an epidemic that we haven't even started to see yet. Yeah. Baby boomers, those born between the years of about 1945 and 1960, are the largest group of our population. They're the largest single generation in the history of the world. And we're getting older. And ask your kids, they'll tell you we're getting crazier along the way. That's a crude term. But the fact of the matter is we are suffering from mental deterioration. Some people with honestly identifiable diseases. But even Alzheimer's, as I understand it, you can't diagnose it until the person's dead and they do an autopsy. So.
And people who have, they have good days and bad days.
Right.
And so there are a lot of times that my grandmother, bless her heart, had days that she was just as sharp as a tack, and then, next day she was 17 years old back on the farm in Aurora. Mentally.
The members of my family have all been just sharp as a tack up until the day somebody shot them or they had a heart attack or whatever it was that caused their demise. But the general rule is unless a court has told you you are not competent to sign papers, you can sign them. Now, the problem with that is if you do something that your brother, sister, whoever doesn't like, they may very well come back and file a lawsuit seeking to have that action nullified or voided, alleging that the person who signed the paper was not competent at the time.
Insider. I mean, Dad's got a $50,000 Mercedes and he sells it to you for $10. Somebody may get upset about that. I mean, but if it does a market value and things that you're doing him for his benefit, I don't think you have a problem. But it's the word about inside
dealing,
undue influence. That's the correct word. Excuse me.
Yeah, there can be problems with it, and again, that goes back to our rule. The first moment that somebody is told by their doctor that they should expect their mental capabilities to deteriorate in the future,
get a power of attorney, durable power of attorney, the next day.
That's right.
Period.
Put it in the hands of someone you trust to deliver it when the time comes for that, and you will save your family thousands of dollars, a ton of trouble, and you'll rest more secure also. We have another call. Mona in Putnam County. Mona, you have a question for us.
Yes. Hi.
Hi.
Yes. I want to know that I have a power of attorney and trust and will, but if I move out of the West Virginia, will I have to make it all over again in other state? Will they honor my West Virginia will?
The answer is yes, maybe no.
There are a few states. In West Virginia, we have a self-proclaiming will that has two witnesses. I know I have a brother and my father lives in Florida. Florida requires 3 witnesses. I don't know that states are very intent about wills. That's something they really want to give full faith and benefit to. But I tell clients, if they're moving to another state, contact an attorney in that state, be it Florida, Colorado, wherever you're going, and verify that. It's very cheap to see. And here's my will of West Virginia. In your particular, because all 50 states have different little rules. That's why they're all unique.
That's why we don't practice in other states. We only have a license in one, or maybe 2.
No, but that's it. So, if you're moving to another state, take your documents, find an attorney in that state, have him or her look at that, and you'll have your answer very quickly. Because I can't. I know Florida requires 3 witnesses.
Louisiana requires 3 witnesses, but that's not fatal to the will.
No,
it's
not.
just fatal to not having to produce witnesses to the will. Because if you need 3 people to witness a will in Louisiana or Florida, or 2 in West Virginia, what they're really saying is, I know the deceased, or I knew the deceased at about the time this will was written. The deceased knew what she was doing, knew what she owned, knew to whom she wanted to leave it. So I believe the result of all that was she was in her right mind at the time she signed the will. And you have to have 3 people testify to that, or in West Virginia 2. So if you have a will with 2 witnesses, that's fine. That's 2 of the 3 that you might need. And you're going to have to bring in that 3rd person. That can be expensive and time-consuming.
Yeah, and it may not be fair. Each state is unique. You just got to I would advise you to when you get to where you move, find somebody, have them review your documents, and you'll have an answer.
I think we have another call. Is it Ken? Ken,
yes.
You're on the line? Go ahead, Ken.
Yes. Dan or Doug, either one, could you discuss just briefly the impact on a couple that is unmarried, has a child, and then one of the parents wants to return to his or her home state without a court order having been entered dealing with the issue of custody?
Actually, in that case, the fact there's no marriage probably doesn't influence very much, because the answer is the same in either case.
Yeah, if the child was born here and has remained here for his or her life, then you probably need to get to court immediately to make sure that this is still the home state for determining the child's custody and primary residential parent. Under the UCCJEA, which is the Uniform Child Custody Jurisdiction and Enforcement Act, we're a mobile society, so people move a lot. All 50 states have signed this, and it's so that there will never, hopefully never, be a child that doesn't have a home state that can determine his or her fate. So if you move to a new state, generally it's 6 months, be there before you can qualify to go to the new state as the home state of this child. So if this is the home state, you need to get to court and get that resolved before it's a problem.
Yeah, and it doesn't matter what state you're in. If you're in Pennsylvania, West Virginia, Ohio, Kentucky, Maryland, Virginia, whatever state you happen to be in, if your significant other, you said there was no marriage here, announces, I'm moving to the land of Oz tomorrow morning, you want to be filing a petition to determine your custody and visitation rights immediately. You can do that even though you're not married.
Right, absolutely.
And if you're divorced, you have a child custody order. Almost certainly in that order or in the parenting plan that you have agreed to, there is language that says you're entitled to a certain amount of notice before a move takes place.
West Virginia, 60 days written notice before relocation, and but generally mediate to see what the changes in the visitation or time with the child is. And if it can't be worked out, you go back to court, and the court will determine. I've seen cases where mom or dad's leaving with the child, said, no, you can go, child stays here. That happens.
Another aspect is, and we see this so frequently, there is a couple, married or not, one is a foreign national and decides that he or she is taking the child and going back to whatever country it is that they were from. Do you have an answer for what to do about that?
Depends upon the country they're going to. There are countries that we don't have treaties with, and that's a problem. You see those on the news all the time. Dads and or moms who can't get to certain countries and they don't care. Get to the court system as soon as you can to get an order, and hopefully that if they go to a country, it's in a country we have a treaty with.
Well, and even if we have a treaty with that country, other countries, as we do, treat their citizens with preference, strong preference. And we're not talking about countries that you have to go to an atlas to look up to see if there really are countries, or countries whose names contain only consonants or something like that. This happens between the United States and Japan. It happens between the United States and Brazil.
England, Germany.
The United States and England, and I probably wouldn't push the Canadians too far either.
Well, again, everybody has a vested interest, which is why West Virginian state courts have a preference over West Virginia residents. I mean, and so does Pennsylvania does the same for Pennsylvania residents. That's why there's 50 different states, and they look out for their own citizens first.
And at least as importantly, they look out for the welfare of the child, and they want to keep the child where the court can exert protective influence over the child.
If necessary.
If necessary, and that creates some real stumbling blocks sometimes. We have another call. Stacy, you have a question about trusts, I believe.
Yes, I'm calling to see at what time should I start creating a trust for my daughter, who's a teenager in high school, to ensure that she receives everything that I've worked for, so that it goes to her and no one ever can take it away from her. What can I do to protect her interests?
Stacy,
and how costly is that versus just having a will?
Stacy, are you married?
No, divorced.
You're divorced. Well, when do you start worrying about taking care of your child?
At birth.
Or 9 months before?
9 months before. You can probably do some of that with a will, so we mentioned earlier, a springing trust. Depends on how you're going to fund it. Decide who you're going to talk to, what you want for your daughter. There comes a point in time, and there's no actual true answer for this. I do not recommend, if something happens to you and your child's still a minor, that children inherit things at age 18. It just doesn't seem to be wise. Some people wait to 21, some people wait 25, 30. There's no magic number. I've seen children at 21 who are extremely mature, and I've seen adults at 45 that I wouldn't let watch my dog anyway. It depends upon the child. So you can tailor this to what you think is the best benefit for your child. And you can fund it with, you don't have to put money in it today, you can fund it with either life insurance or things that come in and hopefully you don't pass away and you get to see your daughter grow up and have grandchildren and when you're in your late 90s, she's pretty well taken care of.
You asked the question, Stacy, how much will this cost? And the answer is, we don't know. We can give you ballpark figures as to what any legal procedure will cost, but we can't tell you with certainty because we don't know during the initial discussion or in a question on a call-in program what has to be done, what the important issues are. To raise something to make everybody uncomfortable, the simple fact of the matter is if you have a minor child and you pass away, that minor child is going to your ex-spouse or the parents or the other parent of the child. There's almost nothing you can do unless that parent is in prison or something like that.
Well, but you can name a guardian of the person. And if you have a brother or sister or someone you would prefer to have the child, I always put that in my wills for the reason that it gives that person a chance. Otherwise, they have no chance.
It's a nomination.
It's a nomination. I've nominated my sister, my brother, as a guardian of the person of my minor child, and the courts look at that so that it's not a slam dunk for the other spouse, the father, to come in and get custody. You know, and if there was a reason for why you didn't want the father to have custody or the mother, whatever the case may be, the courts are going to look at that because they still have the quote best interest of the child. And courts take that very, very, very seriously.
Right. But the problem is if your ex-spouse or ex-significant other does come to be the custodian of the child, then pretty much any money that you have left to provide for that child is going to pass eventually into the hands of that other parent. So I guess the rule is don't have children with people you don't trust. You may not be able to live with them,
but through a will and a spring of trust, she can avoid that. So the money would go to, let's say, your sister who controls the purse strings, even if he does get custody.
Right, and
so
you do that through a trust.
Right.
It doesn't have to be a complex trust, but it has to be a trust. The rule in writing wills is it doesn't cost a whole lot to write a will. The expensive part is figuring out what to put in the will to make sure that it affects your witness, your wishes. And that can be very time-consuming and can be very expensive. And I've had people change their mind a half a dozen times in the process.
And I always tell people, once you do your will, take it out and look at it every 2 to 3 years because situations change.
Yeah, there's no rule against changing your will.
You can change them every day if you can keep up with the paperwork and the...
We have another caller.
Yes,
Lonnie,
sir.
you have a question for us.
Yes. My question is concerning a estate. My brother died, and he didn't have a will, and he left the farm to the heirs. The estate's already been probated, and all the heirs want to sell except one. What options do the other heirs have to sell the farm?
If more than one person owns a piece of real estate, no matter how they came to own it, in the absence of any contracts or business organizations defining how the relationship works between these people, any one of them can go to court and ask to have the property divided up into equal shares, or if it can't be divided into equal shares, to be sold. It's a fairly expensive undertaking. It's a time-consuming undertaking.
And the problem is, when you do a suit or petition and it's sold, you may not get market value.
No, because it's
sold
a forced sale.
Forced sale at the courthouse square, and if it's worth $100,000, nobody's going to pay $100. They're going to pay $60, $70. I mean, they're going to try to get a bargain because you're not getting market value.
Really, the best solution is for everybody to get together, agree that they can't agree, and then list the property with a reputable real estate company, broker, for sale at the highest and best value can be achieved.
That broker will require everybody to sign that agreement because they're not going to...
Yeah, there'll have to be an agreement.
Yeah.
But of course, any one of the owners has the right to come in and buy the whole thing,
right?
If they can. If you can't agree to do that, you're going to end up with an auction on the courthouse square where you may anticipate that one of the other owners is going to come in and start bidding on the property because whoever buys it's going to get a real deal. We're talking about family law, from marriage to divorce, from birth to death, and everything in between, and we're taking your calls. My guest is family law attorney J. Douglas Crane. We're live here in the studio. The number to call is 1-800-375-4049. 375-4049. I'm Dan Ringer, and this is The Law Works, and I don't think we have a caller on the line right now. How long does child support obligation last?
Child support lasts till the child is 18 or graduates from high school or such other date the court deems just and fit. When I say 18, I've had children who are 18 in February and they graduate the following June. Child support goes till June. I've had children who graduate in June, but they're not 18 till July or August. So the court makes it go to the furthest part to support that child. And that's assuming that there are no problems with the child. If the child had some handicap or whatever, that child support is for the life of the child.
One of the things that we see frequently is people saying, I'm going to take care of my own divorce. I don't need a lawyer. My spouse and I are in agreement about pretty much everything. That's a word of warning, pretty much. And we don't need to hire a lawyer, and maybe we can get just one lawyer. First of all, one lawyer cannot represent both of you.
Absolutely
You each
not.
have to have your own lawyers, or one of you doesn't have a lawyer. That can happen. But it's really a bad idea if you have any sort of significant assets or if you have children to try to get a divorce without having an attorney hold your hand. We have another call. Jay wants to talk about child support. Go ahead, Jay.
How you doing, sir?
We're well, sir. What can we do to help you?
Yes, sir. Well, my name ain't Jay, it's Terry.
Oh, I'm sorry. I got the wrong Tony. Okay.
Okay.
Terry. Okay.
State of West Virginia had the child support, and I went to court, and the judge kind of said like a statute of limitations has run out where they backed up till 1986, and my daughter's 31 years old, and I'm a grandpa twice, and my boy's 29 years old, and I was just wondering about your statute of limitations. After 10 years, it's supposed to run out, right?
If I understand your question, sir, what I generally see these is when someone is a paternity action and they're going to go back for back child support, and the fellow may not know this till the child's 15, 16 years old, and they want to go back for the entire time. They generally go back 3 years. The 10-year statute of limitations is you can't go back further than that.
They backed up all the way to 1986 for child support on me.
Okay, well, that tells you what the statute of limitations is. It's long enough to go back 1986. What happens is if the person who's obligated for child support or alimony deliberately hides themselves or absences themselves from the jurisdiction, then it can last forever. The ability to go in and get the money back. I have also seen reference, I've not had personal experience with this, that 10 years after the child reaches the age of majority, you may not be able to collect child support back, but that's if you sit on your hands and don't try to collect it.
But if it's been reduced to a judgment, you can re-execute on that forever.
Yeah, once you have a judgment
And each
you have to
payment,
renew it every 10 years.
Every 10 years, yes, sir.
But it's you get the judgment says you're entitled to collect $1 or $10 or $1 million.
What he may be talking about is the BCSE, Bureau of Child Support Enforcement, has been filing judgments and trying, but they can't execute on them, but they're protecting that 10 years. So that does not last. That could be forever.
Okay. It has been suggested to me by our director that we talk about the subjects in the last couple of minutes of the show of grandparents' rights. Mm-hmm. Now, it need not be a long discussion because it's a pretty simple issue.
There are none.
But I was promised by that person running for the House of Delegates a few years ago that she was going to go down and protect my grandparents' rights.
If you read the statute, it says the title of the statute is grandparent visitation.
Well, that's a right. Sort of.
And it sets out the various criteria for a grandparent to file a court action to go after to see their grandchildren. And it sets out various things that you can do. And the very last one says, if the parent agrees. So if you're not seeing your grandchildren, make up with your children. I mean, if they have a legitimate reason that they don't want you to see your children, and it may illegitimate reason, it makes no difference, but the court is not going to interfere with the parent's right to decide who sees its child, your children, excuse me.
Your child may be the father of your grandchildren. Mm-hmm. It's up to your child to bring the children to you
on his time
to visit with them.
Say they're divorced, which is when this comes up.
Right.
And the complaint I get is, well, my son or my daughter is not bringing him to me. Well, you need to talk to your son or daughter so that because grandparents I have wonderful memories of my grandparents and the times with them. And I was thinking, a child can't have too many people that loves it. That's a wonderful thing.
One of the tragedies, though, is your deceased son may have children and you want to see your grandchildren, but your deceased son can't bring them to you. Your daughter-in-law, former daughter-in-law, doesn't have to.
Well, the case on that came out, and it's been in all the courts. I mean, each state has it, and in the case, this was actually an Iowa case. The mother had died, and son had remarried, and the court gave them 1 week in a month, and
that was it.
Reversed it. Said zero.
We're out of time.
Sorry.
J. Douglas Crane, thank you again for being with us. Thank you for calling in and for being with us. On behalf of the Law Works, I'm Dan Ringer. Good evening. We ought to do this. On the LawWorks website at thelawworks.org, you'll find a listing of recent The LawWorks programs, additional information about this show's topic, and video of this and recent shows. You can also find the LawWorks programs on YouTube and iTunes. If you would like to suggest a topic for a future The LawWorks show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us email at thelawworks@comcast.net or visit us on Facebook.
The Law Works is produced in cooperation with the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law. The Law Works is made possible by a major grant from the West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and legal system, promoting public knowledge of the law in West Virginia. By the generous support of Software Systems Incorporated, a West Virginia company established in 1975, providing high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems. And by viewers like you.
From West Virginia Public Broadcasting.